14A818973, Alfonso Noyola. This is the City of Boulder City.
Hello, this is Richard Gordon, bar number 9036, for plaintiff Stephen Morris.
Okay.
Good morning, Your Honor. Jeff Barr, on behalf of plaintiff Alfonso Noyola. And for time's sake, Mr. Gordon will be taking the argument.
Okay.
And Your Honor, Dennis Kennedy and Kelly Stout on behalf of the defendants.
Good morning, Your Honor. Mike Edwards on behalf of defendants McManus and Folda only.
All right. So this is Boulder City's special motion to dismiss claims 1 through 4 in plaintiff's first amended complaint pursuant to Nevada's anti-S.L.A.P.P. statute, NRS 41.660. I'm going to let counsel argue, but I wanted to provide you with the impressions that I formed after reading the briefing in the case. I did review the October 5th, 2020 special motion to dismiss, the November 3rd, 2020 opposition, and the November 12th, 2020 defendant's reply. In a nutshell, defendant's position is that each of the plaintiff's claims arises out of a truthful communication, or at least one made without knowledge of its falsity, which is to say, made in good faith, and that communication was aimed at procuring lawful governmental action and thus in furtherance of the right to petition regarding an interest of public concern. And then once the defendant demonstrates this, which I believe they did, then the burden shifts to the plaintiff. If the first of these two prongs is satisfied, then the burden shifts to the plaintiff to demonstrate a likelihood of success on their legally sufficient claims. With regard to the plaintiff's first claim regarding the meeting agenda, the declarations of Councilwoman Folda, Folda, and Mayor McManus, McManus, demonstrate to me that they both acted reasonably and in good faith. With regard to plaintiff's second claim regarding Mayor McManus's August 6, 2020 communication, that communication fits within the definition of a protected communication also, and that is supported by McManus's declaration. Plaintiff's third claim contending that by seeking to confer and conferring with prospective counsel, the contention that that is anything but protected communication simply, I find untenable. It is explained in painstaking detail that since one of the plaintiffs was the city attorney and the plaintiffs were seeking emergency injunctive relief, the city had to act promptly to ascertain what its rights and obligations and responsibilities were, and the only way to do that was to consult with legal counsel. They couldn't consult with their city attorney because he was one of the plaintiffs bringing the suit against him. So it was entirely reasonable and appropriate and even necessary for the city to confer with legal counsel. With regard to plaintiff's fourth claim for breach of the covenant of good faith and fair dealing, I think that that is all predicated on the same facts and circumstances alleged in the first, second, and third claims for relief. So the fourth claim necessarily arises out of a protected communication. So my inclination, as you can tell, is to grant the special motion to dismiss for the reasons that I've tried to summarize here. And given the fact that that is my inclination, I'm happy to give Mr. Gordon and Mr. Barr, I guess Mr. Gordon's going to be making the argument, so I'll give Mr. Gordon the opportunity to supplement the briefing that was provided. And I say supplement because I appreciate the briefing that was done. And I thoroughly read it all, so I understand what you had to say. I disagree with the plaintiff's position. And I will tell you, I found it noteworthy that the opposition contained no declarations or affidavits in support of the arguments that were made. So, to the extent you may wish to address that too, you're welcome to do so. So, Mr. Gordon, you have the floor.
Yes, thank you. Great. Thank you very much, Your Honor. And let me begin. The court's well aware. You've read the briefing, and I know are aware of the anti-S.L.A.P.P. analysis here. There's two steps to the process, and we believe, and hopefully an argument I can persuade you in another direction, that the city's motion fails because they can't prove by a preponderance of evidence that the communications were protected by the anti-S.L.A.P.P. statute. And here's why, Your Honor. If I could just take each claim in turn briefly. The first cause of action. Although it's characterized often by defendants in their briefing as a cause of action pertaining to the agenda for the August 6th meeting, that first cause of action has nothing to do with the agenda. It concerns a violation of the open meeting law for defective notice.
Well,
we don't believe that the first cause of...
Hold on, before you go too far afield, though.
Sure.
There's no question. I understood that the open meeting law was the thrust of your position. So I don't think that is. I don't think it's just an agenda issue. I think that everybody understood you were claiming violation of the open meeting law, and I think that was pretty comprehensively addressed. On page 19 of the Boulder City special motion to dismiss, point number 1 at line 3 is at line 9, claim number 1 fails as a matter of law because Nevada's open meeting law does not require the city council to convene a public meeting to decide whether to consider an individual's character, alleged misconduct, or professional competence at a future public meeting. So if that's your launching point, is that the city didn't understand that the open meeting law was really the focus of your attention, that's incorrect.
The court will take this matter under submission.
This is the time set for your hearing on custody.
Don't unpack. That's not what today's hearing's for.
The likely result of that is you will be remanded into custody.
Okay, and are you opposing that?
Counsel, your appearances for the record.
The court has a few comments before we begin.
We are on the record in the matter, case D-505.
No, Your Honor, if I can address that point specifically. The issue here is what does the open, I recognize they see that we're making an open meeting law claim, but they misconstrue what our actual claim is. The claim we make for violation of the open meeting law in the first cause of action has to do with the requirement of NRS 241.033 that any notice given to, in this case, plaintiffs for a character and competency meeting must be given by the public body, okay? And that is the core issue. What was the notice here? They were letters by one unilateral council member, Tola, that were sent to plaintiffs, but were never authorized by the public body. They tried to candidly and very well write that part of the statute out of existence. It's the notice that must be authorized by the public body. And if that's not done, and that wasn't here, there is an open meeting law violation. Plaintiffs do not take issue, Your Honor, with the contents of the agenda for the August 6th meeting. We do not take issue with the contents of the folder letters. And this is really core to the S.L.A.P.P. analysis. Our claims have to be restricting in some way of the free First Amendment rights of the city. We don't take any issue in the first claim or in any of the claims with the First Amendment rights or with the speech of the city. In fact, to really crystallize it and why this isn't a S.L.A.P.P. violation, I think the clearest sign is the agenda for the August 6th meeting could remain exactly the same, verbatim, a word not changed. The folder letters could remain verbatim, exactly the same. And the letters would, so the content of the meeting doesn't address or try to change or alter the speech of the city. But here's where the city made its mistake. The letters were not authorized by the public body. That's the issue that plaintiff doesn't, or the defendants don't address. It's very clear in the statute that notice must be authorized by the public body. What's the public body here, Your Honor? It's the Boulder City Council. And how does the public body act? Plaintiffs can see, defendants can see all of these points. The public body acts through a majority of a quorum of its members. That is the only way that a public body can act under Nevada law. And if that didn't occur here, there's an open meeting law violation. So the speech, Your Honor, in no way does the first claim address communications at all. It addresses this procedural issue, this procedural requirement that the open meeting law, which preserves a statutory and a constitutional right of plaintiffs to proper notice before a meeting to assess their character and fitness. That didn't occur here. And therefore, because that didn't occur, there is an open meeting law violation. And as a matter of law, if there's an open meeting law violation, that communication can't be in good faith. So they don't satisfy, we believe, Your Honor, very first and most basic.
Gordon, that is an entirely circular argument. And I completely disagree with your analysis of the statute involved. I did read the brief. I understand what your argument is. So it's not that I don't understand it. I disagree with it, and I don't find it persuasive. Instead, I find the defendant's position far better supported in the law, and in particular, pages 20 and 21, 20 through 22 of their motion, which persuades me that the Boulder City Charter or the City Council's Rules of Procedure do not prohibit an action before a matter can be placed on the City Council agenda. Any person can submit and request that a matter be placed on the agenda, and that's what.
And we agree with that. No, we agree with that, Your Honor.
The problem is that the argument that you're making for how you think it should work would hamstring the public body so that they would never be able to move forward. They would always be in the process of considering a matter for placement on the agenda, never getting around to actually conducting the business of the city. So anything else?
Well, yeah, all I would say, Your Honor, is we agree with that analysis as to the agenda. That's why the agenda is a red herring. We don't dispute that they could put the item on the agenda. A single council member can do that. That is not our question. But what they can't do is have a unilateral member authorize notice when the law requires the public body to authorize notice. The agenda can be set, no issue there with plaintiffs. The issue is the authorization of notice. They didn't do it according to the statute. Otherwise, Your Honor, their rationale, taken to its logical conclusion, would allow any individual council member, anyone, to simply write a notice letter, serve an employee that they like or dislike with a meeting notice pursuant to the open meeting law to evaluate their competency. Right? They admit as much. Tracy, this is to address your point that we certainly saw in their brief our opposition by declaration. Your Honor, we give substantial evidence to support each claim. The declarations that we are relying on primarily are the city's own. We ask that the court take the city at its word. It's Tracy Folda's declaration that we reference in our opposition, Your Honor, where she says, I, Tracy Folda, individually prepared notice letters and had them served on the individuals, okay? That itself, without evaluating another sentence in the declaration, Your Honor, is an admission to an open meeting law violation, because she's saying, and we make no argument for this, that the individual act of an individual council member is just the act of a public. For that notice to be valid, they have to make the argument. Tracy Folda's unilateral action is equivalent to that of the public body. They don't even attempt it. They simply ignore that express provision of the open meeting law. So the evidence supporting this claim, Tracy Folda's declaration herself, Keenan McManus's declaration that they attached as part of the preliminary injunction proceedings. And it's a similar basis, Your Honor, for all the claims. I certainly see where the court's reasoning is going. But as to each of the other claims, I think what's important to note is simply this. None of the claims, none of them, brought in 1 through 4 by the plaintiffs impinge upon the First Amendment rights, the speech rights, the rights to petition of the city. None of them. In the second cause of action, Your Honor, it's the August 6th email, the electronic communication email from the mayor to the city clerk. email, we did not take it with a single word, single McManus. We simply say, wrong here. Speech. We're not restricting his speech. What was done wrong is the email was sent and CC'd to all of council, which creates an electronic communication for purposes of deliberation. So that's the second cause of action. The third cause of action, Your Honor, this one I think is candidly perhaps the most egregious. And I understand the court thinks differently in its analysis, but let me try, if the court will permit me, to really explain what this third cause of action is all about. In no way, plaintiffs take no issue with the city having the right to speak to counsel, and they take no issue with the contents of that speech. But a city, a municipality, a public body is different from every other client. It is governed not only by laws of privilege, it is governed by the open meeting law. And so when the city communicates with its council, even if that communication is privileged, it must do so in accordance with the open meeting law. That did not happen here in these pre-retention communications. The open meeting law is clear. To be shielded from an open meeting law violation in communicating with counsel about pending or threatened litigation, that attorney must be employed or retained by the public body. There are, and we cite, Your Honor, Attorney General opinions that make this point expressly clear, that the public body, in order for them to have these communications as a non-meeting, not in violation of the meeting law, there must first be an employment and a retention by the public body. And the public body can only retain counsel in a public meeting.
Mr. Gordon, I'm sorry,
Yes.
but this is, it's just not flying. It has no wings. It has no apparent method of forward thrust. It's just falling flat. They couldn't confer with the city attorney because he was one of the plaintiffs suing them. They couldn't confer with the person that he recommended because that person said, you know what, I'm sorry, I can't help you. I do criminal defense work and I am out of my element here. You need to contact somebody who understands these issues, and it's not me. So they then went to somebody who said, yes, we're familiar with this area and we can advise you. And the idea,
but that doesn't.
And the idea that somehow violated the open meeting law is frankly, it's absurd. Okay, so I've given you time. I've let you argue. I don't find the arguments persuasive, so I'm now going to turn my attention to Boulder City. Anything that Mr. Kennedy or Mr. Edwards wish to say on behalf of the clients they represent?
Thank you, Your Honor. Dennis Kennedy, on behalf of Boulder City. The court's analysis is correct. I have nothing to add.
Mr. Edwards?
Nothing to add, Your Honor.
All right. I find the position and arguments of Boulder City and Tracy Folda and Kiernan McManus not only persuasive, but compelling. So much so that in the preparation of the order granting this anti-S.L.A.P.P. motion to dismiss, this special motion to dismiss as an anti-S.L.A.P.P. Proceeding, I want the, Mr. Kennedy, I imagine that your firm is going to be tasked with the responsibility of preparing the order, but I would like very much in the preparation of findings of fact and conclusions of law, if you would closely track from the motion filed October 5th, 2020 at 6:09 p.m., I would appreciate it if you would closely track, beginning at pages 19 through 32, the headline points and subpoints made in support of the motion, because I found them persuasive and compelling then. I found them persuasive and compelling when I reviewed the plaintiff's opposition, and I considered them persuasive and compelling when I read the reply. I do need the order. Do counsel, Mr. Kennedy, do you want to have the transcript of today's proceedings in order to assist you in preparation of the order?
Yes, Your Honor, that would be helpful.
All right. Then what we'll do is I will look for the order about 3 weeks from today.
Yes, we will order the transcript immediately, and we should be able to comply with that deadline.
And if not, then just let us know that you need more time because of getting the transcript and studying it. But we'll set this out for a status check on the 9 a.m. calendar, December 17th, which is about a month out. Status check for the filing of the order. If it has
very
been,
good, Your Honor. We will
been signed and
do our
filed
best
prior
to comply.
that, no need to return.
Okay. Thank you very much.
Thank you, Anna.
Thank you.
Thank you, Your
Thank
Honor.
you, Anna.